put that out. That's what it was entitled to pay for the funeral. Funerals cost a little more than $255 now, so it doesn't quite pay for it. But if you notify Social Security and you've paid into the system at death, you are entitled to a $255 check. But the mortuary will notify Social Security for you. Next thing, your family has to contact, if you have a pension, they need to check with the pension and get that straightened out. Need to call the pension administrator, see how the benefits are going to work. Was there a survivor benefit on the pension or not, or does the pension end? You make sure you ask about any lump sum payments or life insurance. A lot of times the pension administrators don't tell you if there's a lump sum payment or if there is life insurance. You have to specifically ask them. That happened in my own family. My dad passed away and he worked for the railroad, and of course he had a pension. So I contacted the railroad and I got it switched over. My mom had a survivor benefit, and I asked them if there's any other benefits. They said no, that was it. And then about 2 years later I was watching 60 Minutes, and they said, watch out when someone dies working for the railroad, because there's life insurance they don't always tell you. And I said, well, they must not have had life insurance, because I asked if there's anything else. They said no. So I called them and specifically asked them, was there any life insurance? They said, oh yeah, there's $3,500. So they didn't tell us. And I said, well, I asked. They said, well, did you ask about life insurance? Well, I guess I didn't. I just said, are there any other benefits? And they said no. So I need to ask about that, and then specifically ask about life insurance, lump sum payments, whatever, because don't expect the pension administrator to volunteer all that. They don't necessarily do that. Life insurance is another one. Do your family a favor if you have life insurance. Make sure you write it down somewhere, because life insurance companies don't volunteer that information either. There was a lawsuit for one of the largest life insurance companies in the country. There was a lawsuit a few years ago. A dad died. He had a life insurance policy. The kids knew about one policy, collected on it, but it was the Rock, by the way. They didn't tell him about the second one. And then they found out a few years later, and they said the statute had run and they couldn't collect on life insurance, and they sued him, and then the federal government got involved. They got in all sorts of trouble, but they actually hid that from the kids. Kids didn't know there was a policy. So if you have life insurance, in your 3-ring binder we do with your trust, there's a place to list all the life insurance. Make sure you list that. It would have been great if my dad would have listed his life insurance at the railroad, but you should list any life insurance, because don't expect your company, your life insurance company, to volunteer that information. They might. I'm not saying they won't, but there's a lot of instances where they don't. If you're the backup trustee and your parent dies, remember to ask those questions, life insurance, all those things. Then retirement accounts, IRAs. Now that's a big one. Now if your spouse dies, you're the beneficiary on the retirement account. You have some choices at that time. If you're a spouse, you can roll it into your own name and it becomes yours. Only a spouse can do this. Kids can't do this. So if your spouse passes away, if you roll it into your own name, then it comes under, the rules all start coming under your situation. So my IRA says that once I turn 70 and a half, I have to start taking out my minimum distribution every year, and there's a schedule. If I die and leave it to my wife Tammy, she can either leave it in my name and kind of continue that process, or she can roll it in her own name and start over based on her age and her situation. So when would she want to put it in her name? When would she want to leave it in my name? Well, Tammy's not age 59 and a half now, so if I died now and left it to her and she put it in her name, there'd be a 10% penalty if she took it out before age 59 and a half. If I died and she left it in my name, she could pull money out of it without a penalty before she's 59 and a half. Now what if I was married to an older lady, and so I was 70 and a half and she was 90 and a half and I died? She might want to leave it in my name, because then she would be able to take out less than if she put it in her name, because they'd start using her life expectancy. So there are some issues there. So if a spouse leaves you an IRA, you have to decide, and that's why you should come and talk to us. Is it best to just roll it into your name, or leave it in your spouse's name, or some combination? So Tammy might leave some of it in my name because she might need it and put the rest in her name. Because once it goes in her name, she won't have to take any money out till she's 70 and a half. So it depends on her situation. Also, if you have a large estate, there could be an estate tax issue. Let's say we have a real large estate. If Tammy takes that IRA in her name, then it's part of her estate for estate taxes. When she dies, she may want to refuse it and have it go into the trust and have it go on my side to lower the estate taxes too. So that's another issue. So if your spouse passes away, one thing we always ask you to do is don't do anything without talking to us. What we see all the time is with IRAs is when someone passes away, the stockbrokers are Johnny on the spot, aren't they? I think the day after someone dies, stockbrokers are on the front door trying to help out. They're always worried about losing the account. And they always tell you what to do before anybody talks to us. I can't tell you how many times when your family actually finally comes in and sees us, they've already messed up the IRAs because they didn't talk to us. So you shouldn't do anything with IRAs till you come. There's a free meeting at death or incapacity. You should come in and talk to us before you do anything with the IRAs so we can go through those decisions. Is it best to roll it, refuse it, keep it in that person's name if your spouse passes away? So that's pretty important. Now, if your spouse who passed away is 70 and a half years or older and they have an IRA, they're taking out their minimum distribution, aren't they? What if they die and they haven't taken it out for this year yet? Then the backup trustee has to take out that minimum. If they don't take out that minimum distribution and the IRS catches you, there's a 50% penalty for not doing that. So anytime someone that's 70 and a half or older dies with an IRA, the backup trustee should check and see if they've taken out their minimum distribution for the year. If they didn't, then make sure you do that, or else the IRS can impose a 50% penalty. So if the minimum distribution was $10,000 and it's not taken out, the penalty for that is $5,000. So that's real important when someone's 70 and a half. The other thing when someone dies is you're supposed to give a notice to the Department of Social and Health Services. That's DSHS. If the deceased person or their spouse ever used Medicaid, there could be a reimbursement issue. If you went through the Medicaid rules and used them properly, there probably isn't. So if you talked to Matt and did that, he would know. But the law says you have to notify now when someone dies, DSHS, so they can see. And if you don't notify, there could be a penalty. Okay, so Mike's going to go through the next slide because you're probably tired of listening to me.
We're still on notices. So the next notice that should be given out is basically to the trust beneficiaries. Now, a lot of folks have an issue with this if they've disinherited one of their children, and that's an issue if we leave them anything. So basically, we usually advise that people not leave their kids $1 if they're going to disinherit them. You've always heard that. You've heard that advice given you by estate planning attorneys in the past to say, oh, well, you got to leave them $1. No, you don't want to leave them $1 because if you put them in the trust, then you've got to give them notice. You've got to disclose all this information to them. If you just completely leave them out, now you'll put that disinherited paragraph in the trust, then we don't have to give them notice at all. So that old advice is like you say, that's old advice. We don't want to use that anymore. Or the other option is you could give them a carrot, because we have that no contest clause in the trust that says, well, if you come back against the trust, then you'll lose everything you get in the trust. So we want to have a sizable enough carrot out there so that they'll grab that and not go after your trustee for, or go after the trust for anything there. Also, as far as notifying the heirs, there's a statutory time limit once you notify them so that they cannot challenge the documents after that time period. So to get that time period started, once you have that notification sent out, then we get the time period started, and then, like say, after that 4 months, then they're precluded from ever coming back against the trust. So it sort of sets the time frame, and that's why we want to give that notice. As far as giving notice to creditors, the trust says that we're supposed to pay the debts of the deceased trustor. There's some argument that says if the deceased spouse had a credit card that you could